Ready, start. This appeal arises out of final judgment and order dated 9th September, 2022, passed by the High Court of Judicature for Rajasthan bench at Jaipur in SB Criminal Miscellaneous within bracket petition bracket close number 4366 of 2022, whereby the respondent's prayer for quashing of FIR number 131 of 2022 dated 14th April 2022 registered at district Bikaner with police station Pradhan Arakshi Kendra, Anti-Corruption Bureau, Jaipur, for the offences punishable under sections 7, 7A, 8 and 12 of the Prevention of Corruption within bracket Amendment bracket close Act, 2018 and section 120-B of the Indian Penal Code, 1860, was allowed, full stop. Three persons, namely, Bipin Parihar, Chief Marketing Officer, Fern Biofuel Private Limited, his business partner Deven Shah and Satya Narayan Saini, SD of Kusum Petrochemicals, lodged a complaint with the Anti-Corruption Bureau to the effect that the respondent, who is employed as Chief Executive Officer Project Director, Biofuel Authority, Government of Rajasthan, allegedly demanded a bribe at the rate of rupees 2 per liter for the sale of biodiesel, that is, rupees 15 lakhs per month with a further rupees 5 lakhs for renewal of the license of the complainant, full stop. This FIR is numbered as 123 of 2022 under sections 7 and 7A of the PC Act, full stop. This demand took place on 4th April 2022, full stop. A second FIR was lodged on 14th April 2022 for the incidents which took place between 30th September 2021 to 12th April 2022, when one Mr. Shyam Prakash, constable with the Anti-Corruption Bureau, brought information to the notice of Mr. Parsamal, DSP, that amongst other persons the respondent is indulging in taking bribes to grant licenses to run biofuel pumps, full stop. One Nimba Ram and Ashish were the middlemen, who were put on surveillance after due permission from the competent authority, full stop. This FIR, running into nearly 30 pages, details the alleged conspiracy of which the respondent was a part and records in considerable detail the calls received and made by the various persons involved in furtherance of the object of the conspiracy, full stop. The respondent aggrieved by the registration of the second FIR, preferred a petition under section 482 Criminal Procedure Code 1973, full stop. No fresh incident is disclosed by the second FIR, full stop. If fresh information comes to light, it is submitted even after the final report under section 173 CRPC has been submitted, the course to be adopted is not a fresh FIR but further investigation after due permission and then the filing of a supplementary report, full stop. The filing of a second FIR in respect of the allegations that are connected to previous allegations, for which an FIR already stands registered, would be irregular and deserves to be quashed, full stop. Reliance is placed on Babu Bhai versus State of Gujarat, full stop. In this judgment, it is submitted that if there are two FIRs in respect of the same transaction, they would have to pass the double inverted comma test of sameness, double inverted comma close, full stop. Further reference is made to TT Antony versus State of Kerala, which records that a second FIR in a case which is not a cross case, violates Article 21 of the Constitution of India, full stop. The allegations of the second FIR, it was submitted are an attempt to blow up allegations of the first FIR, full stop. No sanction stands taken under the Prevention of Corruption Act for proceeding against the respondent, full stop. The FIR and the consequent investigation, are both against the edict of the legislature and deserve to be quashed, full stop. In the case, comma, the prosecution case is that the petitioner was trapped while accepting bribe through his agent on 7/4/2022 for showing some favor to Mr. Vipin Parihar in discharge of his official duties, comma. The second FIR relates to an incident dated 21/1/2022 wherein the petitioner allegedly accepted bribe from some Shekhawat Ji for showing him some favor in official capacity. Full stop. Both are the offences are identical in nature and committed within a very short span of time. Full stop. The second is incident which was earlier to the subject matter of the first FIR could have been investigated in the first FIR itself as one trial of two charges was permissible under the law. Full stop. Having recorded thus, comma, it was held that the second FIR was an abuse of the process of law. Full stop. On the aspect of prior permission being required to proceed against the respondent, comma, it was found that prior permission was a must and without the same, comma, the impugned FIR could not have been investigated. Full stop. It was with this understanding that the High Court quashed the second FIR in the exercise of powers under Section 482 CRPC. Full stop. We have heard a learned counsel of the parties and perused the written submissions filed. Full stop. The sole question for our consideration is whether the registration of the subsequent FIR is legally permissible and whether the High Court was correct in exercising its inherent powers in quashing the same. Full stop. We find that a judgment of this court titled TT Antony within bracket Supra bracket close records the position that a second FIR is not maintainable. Full stop. A just balance between the fundamental rights of the citizens under Articles 19 and 21 of the Constitution and the expansive power of the police to investigate a cognizable offense has to be struck by the court. Full stop.